Ready, start. The appellants are the claimants who impugn the judgment of the High Court rejecting the claim petition after reversing the award of the tribunal. The claimants alleged that the only breadwinner of their family, the husband of the first appellant, died in a hit and run road accident which fortunately was witnessed by a close associate of the family, a neighbor. The dead body of the victim was abandoned by the driver of the offending vehicle, who, on the pretext of taking the victim to the hospital, left him at a far off place. PW1 is wife of the deceased and PW2 was the eyewitness proffered by the claimants, both examined before the tribunal. The tribunal noticed the objection raised by the insurance company regarding the fraud played by the claimants. It was contended that the alleged offending vehicle was not at all involved in the accident. The driver and the owner of the vehicle were set ex parte. The tribunal held that there was no rebuttal evidence brought in by the insurance company as against the testimony of PW2, the eyewitness. RW1, an officer of the insurance company, had merely raised an objection in his testimony which, though pleaded, cannot be believed since he was not an eyewitness. The insurance company was further faulted for not having examined the driver of the offending vehicle. The contention regarding the delay in registration of FIR was brushed aside on the ground that the FIR was first registered at a police station without jurisdiction, which was later transferred to the jurisdictional police station, the delay having occurred in the transfer alone. The objection of the insurance company having been rejected, the tribunal went ahead and awarded an amount of rupees 16,02,000 to the claimants. The insurer appealed against the award, in which the High Court reversed the findings and held that the accident, as also the involvement of the vehicle, was not proved. The complaint was filed alleging that the accident occurred on 18/6/2014 at 12 a.m. at Crossroad. Actually, the accident occurred at 12 p.m. as spoken of by the witnesses, and the time recorded in the complaint obviously is a typographical error. However, the fact remains that the High Court specifically noticed that the death of the accused, as per the intimation of death given by the family by Exhibit P13, is on 26/2014. Exhibit P-13 was a document produced and marked by the claimants through PW1, which is the obsequies ceremony card. According to PW1, she was informed of accident in which her husband was involved by PW2. PW1 deposed that she went in search of her husband in various hospitals and later was informed of a dead body lying abandoned at a place quite distant from the scene of occurrence. She is said to have taken the body from the lorry stand in front of the BTL college to the hospital where her husband was declared brought dead. An FIR is said to have been lodged on 19/6/2014 in the police station.